The argument for the government was, well, we could ban them altogether if we wanted to. And the court said, no, you can't. That's wrong. So the legal challenge against VAT on private school fees failed. But this is far from the slam dunk win that some ministers will doubtless now gleefully tell you that it was. In fact, it's somewhat embarrassing. Embarrassing in a number of ways. One, in that it challenges the way that this has been sold to you, the general public. And with respect, I think many of you may have been misled about it. But secondly, it is embarrassing in that as a nation that should be proud of what we achieve, what we set up, what we leave for the next generation and the generation after that, in that many of these policies are now destroying that which has been built over many years, of which we should be proud, only now to be collapsing around our ankles. These are institutions hundreds of years old that have been set up by previous royalty in the honor of previous royalty names and so on. I'll come back to that in a minute. But first of all, please do subscribe to this channel here. Help me grow this channel to 1 million subscribers, and then I will know that I've helped at least 1 million people in at least some small way to understand law. I did this on this channel. I set this up because during lockdown, the amount of people that were absolutely desperate and couldn't find access to legal advice was really upsetting. So I set up this channel to help you understand law, and I will continue to do that. Let's take a look. I'm not going to go through in great detail, so don't worry for a Saturday. This will be a broad overview of what I think in general about this decision here. And whilst it went against those challenging the VAT, as I say, it's somewhat of an embarrassing win. It's a little bit like winning a competition because you had a better bat or something, or you had some kind of advantage, and then saying, well, you can keep the win, but this is the reason you won. You know, you had whatever advantage. It's a little bit like that. Let me go to the first thing, which is in paragraph 13. This judgment's available online. It's been sold to you as a tax break all along. They've said to you, we're removing the tax break. And the reason they've done that, I will explain. The reason they've done that to you, I'm spelling things out. I promise you, I'm not teaching you to suck eggs here, but this is generally why they've sold it to you. They put this out because they want the general public to think, these rich kids and rich parents that get this tax break, somehow they get this benefit that everyone else doesn't get. We need to take that benefit away. They need to pay their tax like everybody else. That's the way it's been sold to you. They tell you, we're removing the tax break from these schools and these parents and these children. They can pay tax like everybody else. But that is not true, because those parents pay all of their normal taxes in all of the normal way, and that would ordinarily afford their child a place at a state-maintained school, because it is the local authority's obligation to ensure that there is sufficient education places for their children. They pay those fees anyway. They choose, for whatever their reason, be that because they just choose to go to a private school, or they think that it caters better in certain ways for them, or it's more specialist, or it's a faith school, or the child has needs or disabilities and therefore they want them or need them to go to that school. So whatever the reason is, they choose to send them to an independent school and they pay those fees. What the government has now done is add VAT to those fees. It was never a tax break as it's been sold to you. It was an exemption, because we decided as a nation quite correctly that we should not be taxing education any more than is absolutely necessary. So they pay for those fees because they choose to pay for those fees. Now the government has said, you can pay an extra 20%. And let me tell you the embarrassing bit in this judgment, which is essentially, in my view, it's the court calling out this nonsense phrase passed around by the government ministers. In the judgment, the court says the claimants here, in their written and oral submissions, submitted that the challenged provision had the effect of imposing VAT on educational services when such services have never been subject to VAT before. Now, VAT is supposed to be added on a service of added value, etc. But education for children is supposed to be, we would have thought as a self-respecting nation, something separate to that. So the court specified there that they've made this argument on the basis that it's never been applied before. Then the court says, now it takes a little bit of understanding here to decode the way that the court has written this, to sort of read between the lines and understand the nuance of what's being said here. You'll get my drift. The government parties, by contrast, refer throughout to the removing of an exemption or a tax break. This was, in our view, more a slogan than a legally significant description. We prefer to speak more neutrally of a tax change. The compatibility of the change with convention rights depends on the substance, not on any label attached for presentational purposes. This is the court, in somewhat polite and somewhat coded and read between the lines type of language, saying you've been sold a phrase here. You've been sold down the river as to what this really was all along. The court's saying, no. Let's look at this more neutrally. It's a tax change, i.e. was no tax before and now there's tax. Whether that is lawful or not depends on the arguments against the convention rights. Now, then, some people might think, well, since the VAT, the challenge failed, maybe it was never against any of those rights at all, some people might think, and it may even be sold to you on that basis. Now, if someone were to tell you that this obviously doesn't infringe any of those rights because the challenge failed, I would urge you, and the purpose of my video here, respectfully, to help you understand law, would be to divert you to look at paragraph 59. Subheading, does a measure which impedes access to private education engage Article 2, Provision 1? And Article 2, Protocol 1 is protecting the right to an effective education. So, as I said, the challenge failed, but with that in mind as to what Article 2, Protocol 1 is, let's have a look at this. The court said at paragraph 59, at one stage in the oral argument before us, Sir James for the government, now I'm going to just pause there in a second and say don't shoot the messenger, or in this case the advocate, because the advocates put forward the arguments on behalf of the party. So don't confuse the barrister representing this case with the views that the barrister represents. So again, emphasis there. We don't always agree with the arguments that we put forward. But at one stage, the oral argument before us, the court said, Sir James for the government party, so this is your government now putting this argument forward to the court, submitted that the margin of appreciation accorded to states under Article 2, Protocol 1 to choose how to configure their education systems was wide enough to permit them to prohibit private schools altogether. And the court said that submission was, in our judgment, wrong. So let me spell that out for you in crystal clear language. The argument for the government was, well, we could ban them altogether if we wanted to. And the court said, no, you can't. That's wrong. Literally, that's the argument put forward for the government. The government parties submitted that the margin of appreciation, so their remit under this right to education, allowed them to choose widely enough how to do that, and so they could prohibit private schools altogether. My query to you, is that their objective all along? Are they trying to eradicate private education altogether? Because that sounds very much like everybody is equal kind of state, and I'll leave you to use your own imagination there as to where we end up. But they argue that you could potentially prohibit private schools altogether. But the court said, no, you can't. That submission was, in our judgment, wrong. The court cites case law in the bit in the middle, then the bit in green. The court said, if it is not within a state's margin of appreciation to prohibit private schools altogether, a regulatory measure which had the same practical effect would presumably impair the very essence of the right. We therefore consider that the government parties were wrong to submit that Article 2, Protocol 1 has no relevance at all to measures which affect access to private schools. But that being the case, you might ask, why was the challenge unsuccessful? And what does it really mean? And what was the court's decision and the remit and the justification for the decision as to why the challenge failed? Well, the answer to that is quite stark, but it does give you some ground to decide what you think of this government policy overall. Because many of you might think, well, the decision must have concluded that this has no real effect on the right to education because the challenge failed. With respect, that would be an incorrect conclusion to draw. Because if you look at paragraph 5 of this judgment, it gives you some insight here. And the real reason this challenge failed. The court said at paragraph 5, the beginning of paragraph 5, the court's function when considering claims of this kind is not to assess the merits of the policy behind the challenged legislation, but to assess whether it interferes with the convention rights relied upon and, if so, whether the choice made by Parliament lies within the margin of discretion that must be accorded to it. In other words, they decide whether it infringes on any of those rights, and then they also decide whether it's for Parliament to make that choice. Bear this in mind when you think about free speech, when you think about all sorts of other things, because be careful what you wish for, because if we allow, well, there's nothing we can do about it, but if we understand that this is the status quo, this is what happens, the government can decide something which may or may not infringe rights, and it may or may not be within Parliament's power to do so, we may go down a very difficult path. The bit in green, the court then said, we conclude that the legislation interferes with the individual claimant's rights under Article 2, Protocol 1, and Article 14, read with Article 2, Protocol 1. And Article 14, by the way, is the protection from discrimination. Article 2 being the right to education. So just read that again. The court said, we conclude that the legislation interferes with the individual claimant's rights to education and the right to protection from discrimination. So it does interfere with those. However, the court went on, the last line in green on the top page of this. In the circumstances of this case, however, the legislature has a broad margin of discretion in deciding how to balance the interests of those adversely affected by the policy against the interests of others who may gain from the public provision funded by the money it will raise. So in other words, the government can decide what it does if they think it's going to raise money that can be used for other things, and it's the government's choice. It's entirely down to the government. The court says, we've concluded that the challenged legislation falls within the broad margin, even when considering the claims under Article 14, the discrimination article, where the margin of discretion is somewhat less broad. There's somewhat less of a discretion to discriminate against you from discrimination. We conclude that the challenged provisions fall within it. So, in other words, the court is saying, yeah, we agree that this does interfere with the right to education. It does interfere with the right to the protection from discrimination. And it's the government's choice because they think the money will be used elsewhere. Not to say whether actually it will raise any money or what for. And as we've discussed in another video, this is not entirely hypothecated. In other words, it is not absolutely restricted for use for one thing. So where does that leave us? Well, there's a real danger here because if we now look to a bit of news and what's being said by ministers on other matters and whether we can trust what they say, this is quite a stark comparison. If we look at this story here, now this is not the only story, but it's certainly one of them. Now the sun's come out, so I'm going to change the ISO settings on my camera a little bit and turn that down a little bit. There we go. But I'm leaving the blinds open because it's Saturday and it's nice and sunny outside. But this is not the only story, but this one story in particular about Queen Margaret's School for Girls in York. This is a school with a 125-year history, of which we as a nation should be proud, should we not? Should we not be proud that we have private schools that date back hundreds of years with tradition and excellence in teaching? Should we not be supporting those and helping them to thrive rather than hammering them with VAT and forcing them to close? Now, okay, some people will say it was a struggling business anyway, whatever. But any business that is struggling, you should be, if you take pride in that business, you should be helping it, not slapping it with an extra 20% of VAT to pay on top of it, which means, of course, many of the parents just simply can't do it. The school may not be able to pass all of it on. And some of the ministers said, oh, they can choose whether they pass it on or not. No, they can't. No one can just choose whether or not they pass on 20% of additional costs to them. If I said to you watching, with great respect to you, if I said, right, 20% of your salary is now deducted at source, can you survive? Can you still pay for everything that you pay for now? Do you have a 20% buffer? Some of you might. And if you want to build that wealth, join my money channel link below, Daniel Shensmith. I'll link that below. And if you want my blunt and frank views on all this, check out my new Off the Record channel. I'll link that below as well. Thank you all for I'm almost at 50,000 subscribers on there now in literally a few days. So thank you so much from the bottom of my heart for doing that. My personal views on there. Some of my personal views come out on here, but certainly more so over there. Pop over there and subscribe. But this is a travesty. There is no way other than saying this is an absolute disgrace that as a nation, we hammer these schools with hundreds of years history, with royal appointments in some cases, and hammering them into the ground so they have to close. But then, can we really trust what ministers are saying? Well, let me take you to this little doozy of a clip here. This is completely off the subject, but this is, can we trust what ministers say? Now, Darren Jones here is the Chief Secretary to the Treasury. Listen to what he said about illegal migrants to the UK.
And when you see that the majority of the people in these boats are children, babies, and women who have been... No, they're not. No.
So ridiculous that people laughed. Seriously, in the audience. People laughed because that statement was so ridiculous, because it's patently untrue. So how can we trust what they say? Genuine question to you. We have a number of letters now firing about, and this is the situation. Bearing in mind we've got now policies that are shutting down schools and essentially punishing the parents that choose make decisions for their children's education. We have Rupert Lowe challenging him directly on this. Dear Chief Secretary to the Treasury, you stated last night on BBC Question Time the majority of the people in these boats are children, babies and women. This is a lie. Home Office figures show that 73% of small boat arrivals in 2024 were adult males. An urgent public correction would be appreciated. I would also respectfully suggest an eyesight test. I love the tongue-in-cheek dig here because, seriously, if you can't see that, you must be blind, is what Rupert Lowe is saying here. Not the only one. Chris Philp, MP, of course, also wrote to Yvette Cooper. Same thing, quoted it out and said, this is false. In fact, in July 2024, 85% of small boat arrivals being male and 75% of these being adult. Comparatively, just 11% were female and 11% were children. And at the end, on that basis, what's the source of the data? Have you got it? He was a little bit more forgiving here than perhaps I might have been, and said, "Will you correct the record on his behalf?" Also copied in the national statistician, obviously, to see whether those numbers are true or not. Because actually, if we go to, and this is, again, it's the government's own information here. I often say, as a lawyer, one of the best ways to call something out and to prove that it's wrong is to take them to their own source, what they themselves have said, and say, oh, hang on a minute, you said this before, now you're saying this, it's contradictory. And this is sort of, barristering 101. Take them to what they've said previously and contradict it. And then they have no choice then to accept it or correct it. And it says here, in 2024, there were 43,000 detected irregular arrivals, so arriving here illegally. And then we go down to the nationalities and demographics since January 2018. So this is sort of normalized. I'm not a statistician, but normalized over a longer period of time. Back to January 2018, 70% detected were males aged 18 or over. So this is right back to 2018. So these figures are absolutely crystal clear and on the government website. So, you can't tell me that this is me getting it wrong because I'm relying on the government sources here. That's what they say in official statistics. But when you've got ministers telling you one thing in live, I think it was live questions on air, when the stats tell you something different, you have to sort of challenge yourself of what to think. But then also when they're selling you the VAT on school fees as a tax exemption, etc., I think with respect, I think you're being misled. And so I would urge you to look at the truth. And that is what I aim to do on this channel. So I hope that brings some clarity. So please do remember to subscribe to the channel for the clarity. And as always, thank you for watching.